we are now going to turn to a general Q&A session in which my co-moderator will rejoin, and indeed will your co-panelists. Elise, I'm sure everyone will be tired of hearing my voice, so I think I'll mute for a second and leave you intervene.
Sure. Well, actually, if I might, Professor Desiato, I might ask you to pick up where we left off, which was with a discussion of the enforceability of international arbitral awards as a key feature of business and human rights arbitration. And perhaps you could elaborate, and of course other presenters should feel free to jump in, but what are the key challenges that you see to enforcement of human rights at sea arbitral awards, and perhaps offer some potential solutions?
Thank you, Elise, for this question. In regard to the enforceability, we'd have to take a look at Article 1 of the New York Convention, 1.1 and particularly 1.3, because in Article 1.1, I don't have the slide before me, but I'll read it out. It applies the convention to the recognition and enforcement of arbitral awards made in the territory of a state, other than the state where the recognition and enforcement of such awards are sought, arising out of differences between persons, whether physical or legal. Now that's the general rule in Article 1.1. There is, however, a commercial reservation that is possible in Article 1, paragraph 3 of the New York Convention, where it does say that when signing, ratifying, or acceding to the convention, etc., any state may, on the basis of reciprocity, declare that it will apply the convention to the recognition and enforcement of awards made only in the territory of another state, and may also declare that it will apply the convention only to differences arising out of legal relationships, whether contractual or not, which are considered as commercial under the national law of the state making such declaration. So projecting forward, if we were going to take a look at potentially a business and human rights arbitration arbitral award and whether or not it would be enforceable, say, in a coastal state or in a port state or in a flag state, we would have to take a look at the national law of that state to see if there is actually a commercial reservation under Article 1.3. And even beyond that, because the interpretation of what is commercial, of what is a legal relationship, whether contractual or not, differs jurisdiction to jurisdiction. As arbitration practitioners well know, the United States has in certain cases treated commercial in a very broad sense. For them, it's in one case cited in some of its jurisprudence, it refers to all matters excluding matrimonial or political matters. And in other jurisdictions, even torts are deemed to be considered as encompassed as in the phrase, whether contractual or not. India, and for example, the High Court of India is well known for having the broadest possible definition on the possibility of such cases being even falling outside the commercial exception to recognition and enforcement. So at least from my reading of it, there's actually a broader compass to enforcement than we would expect, especially since most of the countries in the world are signatories or parties to the New York Convention.
Thank you very much, Professor Desiato. Does anybody have anything to add? Martin, perhaps you might like to say.
Yeah, I mean, I think Diane has elucidated some of the more technical issues, and really that commercial exception is one of the hurdles that is faced. The Supreme Court of Canada, in fact, very recently held a Uber's standard arbitration agreement with Uber drivers to be unconscionable, and in the process also opined that it was non-commercial there. I think, unfortunately, the grounds that they held applied the framework a little bit too restrictively as compared to what Diane has stated in respect of the U.S. But I think there's a broader point that especially the Hague rules were trying to encompass, which is when you give them something that they want to enforce, that is worthy of enforcement, courts will go out of their way to enforce them. So And that was exemplified in the context, for example, of the Iran-US Claims Tribunal, where there were a lot of these questions as to whether or not Iran-US Claims Tribunal awards fell into neat categories within the New York Convention. The US courts said, well, we see a reason why we might say no, but clearly this is something we should enforce. Yes, it's under the New York Convention. The UK courts actually said, well, no, it doesn't technically fall under the New York Convention, but we're going to enforce it anyway. So I think in this space, it's that question of rights compatibility and the tribunal taking a moment to reason why their award is rights compatible will help a court understand this is not against our public policy. Maybe it's commercial, maybe it's not, but it is something that's furthering public policy objectives that we also want to give effect to, and so we're going to enforce it, regardless of the niceties of international arbitration law.
Thank you, Martin. John, I don't know if you want to do tag team or whether I can launch into another question.
I was just going to add to that the question of going back to the issue of consent and the extent to which, you know, a valid and binding arbitration agreement may seem to be in place, depending on the modalities by which the consent is being obtained. And Emmanuel in his presentation alluded to this. And obviously the concept of consent is more elastic than it might have been initially. Do any panelists have any concerns about enforceability issues on that basis, or even attempts to stymie the arbitration process on the basis of a non-valid arbitration agreement? I'm not directing it to anyone in particular. If anyone wants to.
Yeah, maybe I start. That's the reason why I am not suggesting to go as far as forced consent or mandatory consent. It would have to be a real consent, and certainly not more than in sports arbitration, which is for which the New York Convention does apply. But when it becomes mandated by law, then you have in certain jurisdictions certain reservations. And it's true that dissociated consent may also create questions: have you really consented, and so on and so forth. And yes, Diane is right. There are jurisdictions which would not recognize awards if they are not in the commercial sphere. Although one answer, there are, you know, not that many, but still a number of them would say that. But then they can enforce under their, as Martin said, under their normal domestic arbitration rules. And also one aspect of it is you can deem commercial the relationship for the purposes of enforcement. And that is something which is done in the field of investment arbitration. It also may create problems. But at the end of the day, I wouldn't like to leave the audience with the idea that it's not effective. It's a matter of degree. And I think what is clear, and I'm sure everybody will agree with that, is that an arbitral award is easier to enforce than any court decision, unless you are in an integrated region like within the EU. Of course, it's an Italian judgment is easier to enforce than an award in France. But unless you have, or in the US, you know, full faith and credit in the US. But other than that, internationally, awards are easier to enforce than judgments. So it's a progress.
Thank you, Manuel.
Perhaps if I could jump in, we've received a number of questions from the audience asking about how business can be encouraged to sign up to a system that could potentially expose it to liability. I was thinking perhaps, Eric, this might be a question for you. Could you explain why ship owners and operators might be attracted to registries such as the Commonwealth of Dominica Maritime Administration, as opposed to the so-called flags of convenience and open registry that we've heard so much about today? What are some of the benefits to business to registering under a flag of responsibility?
Thanks, Elise. You know, one of the things we tell all of our owners is that compliance actually creates opportunity. And if we have the mechanisms and the tools for our ship owners and the support for our ship owners equally across the board, that promotes compliance with the international instruments and treaties, not only in fact, but above and beyond in how they relate to crewing. Crewing is a big deal for us, in fact. You know, we even provide a very comprehensive platform, especially important in these days. We at Northeast Maritime Institute have spent millions of dollars developing online simulation because mariners have had to spend so much time at school versus at home when they're on their hard-earned vacation periods. And the owners actually really like to adopt that type of creative system. Not only are we developing a better educational system online, which originally I was against, but we're producing an educational platform that provides tools that are better online than in the traditional classroom. These are the type of mechanisms that go above and beyond. So when we're looking at compliance, compliance is always the minimum standard. How are you going to set yourself apart from the minimum standard? How are you going to go above and beyond? Charterers are going to look at those companies that comply. It's really that simple. If I'm in compliance and I bring my vessel, there's no risk to the charterer. There's absolutely no risk to the charterer, or highly mitigated risk. So in fact, you know, when we go out and we say, hey, to folks, you've got to be in compliance and you've got to do these things, even if we don't have treaties that are ratified yet by the government, we still as an administration require compliance with those treaties. And we have the mechanisms and the tools to do that by policy and through other legal mechanisms. So what we're finding out is that we have very few headaches with our vessels trading to the United States and Asia and Europe, and you know, but we're picky as well. We don't look at this as a way to generate revenue as much as it is a way to study and create opportunities. I've been amazed by how supportive our owners have been once they register their ships with Dominica. They kind of always respond with, hey, where have you been? Where are you guys? We don't advertise, we don't market. And it's pretty neat to see the owners come to us and actually start to develop good reputations themselves as a result of working with us. And yes, we do have a few bad apples once in a while, especially during these times. We're managing a lot of headaches right now because of COVID. But the reality is, if we can provide the tools for our owners to safely, efficiently, and cost-effectively operate their vessels in this pretty heavy regime of compliance, we're doing them justice. And I think it's actually working. And we're getting more and more traction as a registry that doesn't market and doesn't have a sales team. We really don't hang our shingle. People are finding out about us. And it is fun because, in fact, one of the greatest things that we have going for ourselves is our STCW compliance program and our Maritime Education Training and Certification program. It is neat. And really, we're doing it in a very humanitarian way that supports mariners in a way that I don't think they've ever been supported outside of the traditional national flags. And I'm really proud of that.
Thanks very much, Eric. I'm going to use my privileges as a host here to jump in and ask the next question, because what you were just addressing now, Eric, is one of the points I really wanted to build on. It's attracted, as Elise has noted, a lot of attention, both from this audience as well as outside this event, including by James Turner's critique of the white paper. So I wanted to sort of make a comment and also leave it open to further comment by perhaps James and Robin. I think you'll probably be the best to address this. So this morning I opened up my iPad and was reading the daily shipping news reports that I get. And one of the things that I saw, one of the headlines, was CMA CGM Group commits to fight illicit trafficking in protected species and tightens its shipment control procedures. And knowing we had this event on today, the first thought that came to mind is, okay, this is great, illicit trafficking in protected species. Why not illicit trafficking in persons? I hope we can all agree that we're seeing the start of a sea change, pardon the pun, towards more ESG, more protection of the environment, more consciousness of human rights. And I don't think the maritime industry is exempt. I'm starting to see it happen there as well. So the question that I put to you is this not an opportunity for us to start insisting on things like consent to arbitrating human rights disputes? Should we not be afraid of that because of these changes?
I think that COVID has provided a fantastic opportunity for that sort of activity, Alex. And the reason for that is that the ongoing plight of seafarers has attracted a lot of, in old language, column inches in the press. Unfortunately, it tends to be rather focused on the cruise industry, perhaps because journalists think that the general public can only understand the cruise industry, but there's been a fair amount of coverage of the wider shipping industry. And I think that provides a good jumping off point for bringing it to wider attention and for giving it some commercial traction. And I completely agree with Eric and with Emmanuel that there is compliance is a selling point, and it should be. And so yes, I think you've got to have your product reasonably well set up to sell. So it's all very well saying, well, now is the time to arbitrate your human rights disputes. But the answer is going to be where. And obviously a white paper has an answer. I might posit a different one, or indeed several different ones. But that's detail. It's detail that needs to be addressed fairly quickly. But my long answer to your question is yes.
And just maybe to add to that, I think the whole idea that there might be exceptions needs to end. I believe we need to get into a way of thinking, a way of behaving where everyone understands that, hey, human rights standards apply to all organizations. It doesn't matter who you are. And it begins, a bit at home with a bit of homework, looking around our own organizations and saying, okay, do we have our own commitments towards all of this in order? Are we being public and transparent about those? So that there's also some examples for others to follow. Going to Alex's question on hey, is it the right time to ask? It's always the right time to ask. That to me is the key. One thing that we learned with the responsible ship recycling standards was most companies didn't agree to it the first time we asked. So you have to be prepared a bit for that. But the second, third time we asked, they generally signed up, and they'd also heard it from another party. And that's the power of bringing together a coalition of banks that are working on it together. It's also the power a bit of standardization when we start to look into this. My hope is it just becomes a standard part of due diligence. It's exactly what we should be looking for when we're doing and performing due diligence. It's certainly one of the things we look for as a bank when we're doing our due diligence. It doesn't mean it's always in place or that it's always perfect, but it's definitely part of the conversation. And I think that's what's important.
If I may add something to this, I guess there is some sort of a change of culture which can be observed in the last decade. If I look at the industry of private security companies, I remember that I organized in 2009, when piracy was about to spike, an expert meeting with like different stakeholders, and there was a representative of an umbrella organization of PMSCs, so private military and security companies, and he said, and this was a public event, he said, like, who would ever dive after a dead pirate? That was 2009. And today we are about to elaborate a maritime annex for the Montreux document, setting out the obligations of states vis-a-vis private security companies. So that's a huge step. And I guess it's really like by engaging with stakeholders and by being realistic, not asking the impossible. And I guess James Turner made that point quite well. I think we can have at least a slow change of culture.
John, did you want to take the next one?
Yes, it was more just a passing comment, because I think in the time available, we probably don't have time to address it, and perhaps something for another day. But turning to the issues, or turning to the cases themselves that may arise, it seems to me that they could be potentially complex. I think in his typology, Emmanuel listed a number of relationships in which these disputes may arise. The white paper refers to third-party beneficiary clauses, which could operate so as to enable someone to take up an offer to arbitrate, and that being the victim. Martin gave a very interesting exposition of how one particular or two particular cases worked that were administered by the PCA. Are there any concerns from the panelists as to whether the disputes are potentially complex, especially given that the victims may be crew and they're not sophisticated users of the arbitration system?
That's one aspect of what's necessary, is to set up some legal aid support. And I'm sure that would be relatively easy to put in place, using the resources of a few major universities in the world.
Maybe to add to that, there's an initiative out of South Africa that is helping in the agriculture sector, actually, workers to better understand their rights and how to pursue them. And it involves using visuals rather than word-based contracts. And maybe that would be something that would be useful in this situation, just to make sure that workers are well informed, but also that owners have signed the same documents and recognize those rights. I think that certainly was helping there, and quite large companies in the agriculture sector. I think Unilever was one of the companies that was using those in parts of their agricultural supply chain.
Thank you for those insights.
John, if I just jump in to add that there's I mean, I may be the only lawyer on this panel who has actually represented ship's crew, and ship's crew are often, as many workers are, members of unions, and unions, of course, provide, on the whole, a ready-made source of legal support. Although one talks disparagingly of what the crewmen will understand, actually they're perfectly well able through their union representatives to give very good instructions and understand perfectly what is going on, and pay for their lawyers.
Thank you very much.
Elise, I would suggest one more question, maybe to your panel members, and then I wanted to give David a chance to make some closing remarks.
Thanks, Alex. Perhaps flowing on from what we've just been discussing, I note that the Hague rules require arbitral tribunals to play a more active role in ensuring that both parties have an effective opportunity to present their case. Perhaps this is something for Martin and Professor Desiato. Do you foresee that arbitral tribunals will step in and play a more inquisitorial role in arbitrations dealing with human rights abuses, given the, at times at least, significant imbalance of power between the two parties?
Sure, I can attempt a quick answer at first. I think the answer is clearly yes, but that's reflective of the attempt within the Hague Rules to try and answer the questions for all the scenarios that could be envisaged in this space. And obviously when you can have, as you did in fact in the Bangladesh Accords arbitrations, a union of exactly the kind that James was referring to, who was acting in a representative capacity and able to quite ably represent its members, you don't quite have the same imbalance of power, equality of arms considerations that you might in a different context. And the real question is that the tribunal needs to keep in mind that there's so many different constellations, as Anna alluded to, and you're going to have to keep an eye to which one are we in and what are the specific concerns that we're going to face in this particular scenario.
And I think if I may add to that, it is not as if arbitral culture, especially in the last 10 years, has not already been dealing with human rights norms or with environmental norms insofar as they are pushed in other forms of arbitration, particularly in investment arbitration or interstate arbitration. The PCA docket is very well known for this, particularly with path-breaking awards, where tribunal members themselves have taken into account the evolutive nature of human rights law and environmental law. So I don't quite see this as being inquisitorial as so much as it being a conscious recognition of what norms are involved and the complexity of those same norms, contract as well as human rights law, that will come into play. But I do think there's a finessing of arbitral culture, at least if we take a look at jurisprudence over the last 10 years, especially from the PCA. And in that respect, I'm a little bit more optimistic.
Thank you very much, both. I believe that is about time. David, would you like to make some closing remarks?
Well, firstly, thank you very much to everybody. And it comes to me to wrap up after what has been really quite an extensive webinar. My first point is one of highlighting positive change. And in my position, you have to be an eternal optimist to do this job. You certainly don't do it for money. Having established the civil society platform in 2014, when those 4 words, and I started out talking about those 4 words, human rights C, were actually limited to academic development and discussion, today, I can honestly say that I am amazed to hear so many experts and attendees speaking and indeed being galvanized about human rights at sea and how we can collectively develop innovative solutions which, crucially, are victim-centered, thereby empowering individuals who may not have access to employer, flag state, port state, coastal state, or indeed union support. And so today, really, this event has been part of the continuing development of the emerging DNA of not just our charity, but of the wider human rights at sea. And I'll use that word, ecosystem, which itself has made huge strides, bringing this human rights at sea, not the platform, but the concept into common language use across policy, legal, and academic developments. So we're going to continue doing the right thing and publicising it for public awareness. And we note James's points about bringing the shipping industry on side, a challenge that we continue as civil society organisation to face, indeed have faced for the last 7 years, with much respect, generally requires one to be inside the club. But clubs have unwritten rules, and that may not necessarily fit with what Human Rights C and other NGOs are attempting to achieve. So we'll see. It should also be noted that reputable civil society organisations are fundamental to the fabric of society, in pushing agendas into the public eye, tackling difficult subjects and cases, and challenging lack of transparency and exposing impunity or corruption. And we note in terms of this project that success in terms of achieving effective remedy for victims is not going to be achieved just by one route or one entity's prerogative. but by providing multiple pathways which can be adapted in the context of a particular reported incident or human rights violation. So we at Human Rights see, when we speak of abuse and violations, we mean contravening international law norms and establish fundamental rights under the 1948 Universal Declaration, as well as established labour conventions such as the Maritime Labour Convention 2006. And we haven't spoken even about the whole fisheries sector of the ILO Convention 188, the Working and Fishing Convention. But we would say that you can't have a halfway house of dipping one's toe into the human rights pool and then retracting it when one is challenged or matters become a little difficult to either hear or see or read about. For example, most recently, we've been dealing with a murder case in the Pacific in the $22 billion tuna industry, where there's been a lack of transparency, poor access to facts and evidence, and real frustrations with stakeholder engagement. And really, for ourselves, the biggest civil society challenges are the corporate and legal veils, which really prevent access to the evidence, the facts. And these do need to be challenged if the case is genuinely in the public interest. These are otherwise we have found being convenient excuses for not disclosing what has occurred in a number of cases that we have investigated and indeed highlighted. So in addition to this arbitration project, if you're not already aware, we're concurrently driving forward with the developments of the Geneva Declaration on Human Rights at Sea, which was issued last year, with a second version now shortly to be published, and indeed involving the likes of Professor Petrie. In fact, at the opening of this webinar, I spoke about those 4 rules which underpin our work, and you may not be aware, but they come directly from the Geneva Declaration's substantive text. So we've also highlighted and seen that it's unacceptable for flag states not to uphold their legal responsibilities, and that flag states must take responsibility. But that's balanced against the complexity of the shipping industry, which we've spoken a lot about. And this provides a key challenge in this project in terms of industry consensus and indeed acceptance or not of the consent to participate. And as I sort of come to the end of my wrapping up session, for us, securing consent for victims of human rights abuses at sea to access the properly constituted arbitral tribunal that can enforce effective remedy, as highlighted by Professor Galliard, is going to be key to our success, and we can't shy away from that. So we aim by next week to ensure that all of these recorded sessions, and indeed the presentations provided, are uploaded to the Human Rights Sea website alongside all available existing documents. In due course, we intend to develop a landing page as a repository for all aspects of this project, so anybody can download. Finally, I would really like to thank and conclude by sincerely recording my appreciation and our appreciation for the high quality speakers we've had, both of our moderators and most importantly, our attendees. We do hope this event has been of use to you. And I would like to end on and indeed leave you with the charity's call to action, which I hope sums all of this up. And that is the application of human rights throughout the maritime environment at all times and without exception. So thank you very much from me. Be safe and be well.